everyone. Welcome. I'm Eugene Soar. We're going to be starting in just a second. We have quite the crowd today. This is being live streamed and recorded, so please be aware of that going forward. I ask that you turn off your cell phones if you have not done so already. I didn't have mine with me. If you need to exit the courtroom during the oral argument, please use the back door. And any questions from counsel? All good. How much time are you planning on asking for rebuttal? 5 minutes. We will set that. Thank you. All right, thank you.
Good morning and welcome to the North Carolina Court of Appeals. I'm Richard Dietz, and joining me on the panel this morning are my colleagues Judge Toby Hampson and Judge April Wood. I'd like to extend greetings to our Clerk of Court, Gene Soar, who's with us this morning, and also Deputy Supreme Court Marshal Richard Remillard. And we have a large audience in the courtroom today, so I'd like to welcome them. I know we have law school interns from here at the Court of Appeals, from the Supreme Court, and also from the Department of Justice. And we also have some scholars from Fayetteville State University. This is the Judge Ola M. Lewis Pre-Law Scholars Program, so we extend our welcome to them as well. So we have one case on the calendar this morning, and that is number 21709, Kelley versus State of North Carolina. We've confirmed the parties are ready to proceed, so we'll hear from the appellant.
Good morning, and may it please the court. My name is Laura McHenry. I'm from the North Carolina Department of Justice. And with my colleague, Tamika Henderson, I represent the State Education Assistance Authority and the state of North Carolina. I'm joined today by counsel for the legislative interveners and also counsel for the parent interveners, with whom I'll be sharing the time allotted for appellant's argument. As a group, we request 5 minutes for rebuttal. The issue before the court today is whether the trial court erred in denying the defendant's motion to transfer this case to a 3-judge panel. Section 1-267.1A1 of the North Carolina General Statutes provides that any facial challenge to the validity of an act of the General Assembly shall be transferred pursuant to Rule 42b-4 and shall be heard and determined by a 3-judge panel of the Superior Court of Wake County.
I want to ask you a preliminary question. I think your friends for the appellees may disagree with your answer to this, so I want to start to flesh this out. But is this a challenge to the statute? If you read the complaint, it refers repeatedly to a program, as if, and to implementation. So there may be an authorizing statute, but one in construction of the complaint is that what they're assuming about is not the validity of the statute, but some government program that's run pursuant to the statute. Is there a difference there in your mind?
In this case, no, I don't think there's a difference. The reason being that the statute outlines exactly how the program will be implemented. So the challenge to the program is a challenge to the statute. Section 1.267.1 is the statute that requires transfer to a 3-judge panel when the challenge is facial. And that statute is not ambiguous. It does not leave discretion to the trial court judge. It requires that if a party challenges the constitutionality of a North Carolina statute on its face, that case must be, or that challenge must be transferred to a 3-judge panel.
So where in the complaint in this case do you contend that there is an allegation that the act itself is facially unconstitutional?
Your Honor, I think the complaint as a whole does challenge the statute on its face. And today we would ask that you keep in mind three principles as the court evaluates the type of challenge that's raised in the plaintiff's complaint and determines whether the trial court erred in denying transfer. First, this court is not bound by a plaintiff's characterization of a constitutional challenge as either facial or as applied. Second, allegations that require a generalized inquiry from the court in order to resolve a legal claim rather than a fact-finding inquiry specific to the statute's application to the plaintiff signal that a constitutional challenge, however styled, is facial. And third, the requested relief that would invalidate or enjoin the application of the statute entirely is a hallmark of a facial challenge.
So these the terms you're referencing, facial, as applied, so they are terms of art. So your view is when we look at this statute, when we look at the question of transfer, that we're applying not the ordinary meaning of those words, because of course they do have ordinary meanings, but in English usage, but we apply them as the terms of art as they've been construed in the case law. Is that your interpretation?
I'm not sure that what you've described is my interpretation, but I think what we're applying a principle that goes back to Shakespeare, right? A rose by any other name would smell as sweet. The label that is provided by a plaintiff is not the determining factor. The United States Supreme Court has told us that. We really have to look at the claims that are being made. We need to look at the allegations, and we need to look at the relief requested.
What I was getting at is, you could look at something like a facial challenge and construct the meaning of that by just saying one ordinary English usage. If you were to say something is facial, it would mean on its face, and as applied would mean in some circumstance, not others. But what you've described, what the case law has created, is a much more nuanced understanding with tests that you're using and that sort of thing. And I'm trying to understand, in construing the statute, are we just looking at those words and interpreting them as we would any words in a statute, or are we applying, sort of incorporating all of this case law over many, many years in the constitutional context that courts have described what these two terms mean? Are you following me?
I think I'm following you. And yes, Your Honor, this is complicated. There are a number of statutes that are referenced, they're cross-referenced among each other in understanding North Carolina law and what the General Assembly has required when a party raises a constitutional challenge to an act of the General Assembly.
And what cases will we look to? So there's a broad spectrum of cases. So for example, there's one definition in the U.S. Supreme Court that they used in Citizens United. There's many other times the U.S. Supreme Court and many other federal courts have used these terms. Of course, we have used them here in our state courts as well. Do we use state precedent in determining what they mean? Do we look to the federal court's interpretation? How do we decide what these words mean in the statute?
Sure. Well, we're applying North Carolina law, so I think North Carolina Court of Appeals and Supreme Court decisions are provide our primary source of guidance for how to interpret our laws. There are also some federal court cases applying North Carolina law or speaking on this issue generally, and those also provide guidance. Ultimately, the appellants have filed petitions for cert, and part of the reason is because this is complicated, and it's novel, and it's not clear to trial courts or to litigants exactly how these sort of issues should be handled by our courts.
And since you mentioned the petitions for certiorari, I do want to make sure y'all take some time to address the appellate jurisdictional aspect of the case, wherever it sort of fits in the argument, but explaining why, albeit in an interlocutory order, this court should review it.
Yes, Your Honor. I'm happy to briefly touch on that, and then we can discuss it further if you have more questions for me. There's been a motion to dismiss, of course, that suggests that Cryan and Hull, among others, perhaps require dismissal of the appeal at this stage. We disagree, obviously. We think that Cryan and Hull are distinguishable, and ultimately we believe that 1-81.1A1 is a venue statute, and that that defendants have a substantial right, and therefore, even though this appeal is interlocutory, it still is immediately appealable. Now, whether the court agrees with us on the issue of Cryan and Hull being distinguishable, or whether the court agrees to grant the petition, the court has various avenues to get to jurisdiction on this interlocutory order.
If the plaintiffs, in addition to all the other claims that are in the complaint, brought, let's say, a tort claim, and put aside sovereign immunity, all those sorts of things, but brought some other unrelated claim in the case, under Hull, could we order the transfer now of these claims, in your view?
No, I think you've pointed out the distinction in Hull, right? There were multiple claims that could be resolved without the need for transfer to a three-judge panel. Here, we do have multiple theories of some unconstitutional application or implementation of the statute, but ultimately, the next stage of this litigation is for an analysis of the merits. And the merits, so the next stage in this litigation is going to be, is this statute unconstitutional for any of the reasons that plaintiff posits?
Let me ask a follow-up to that, because again, this may be an area where your friends for the appellee disagree. If we think that there are facial claims in the case that would need to be transferred, but there's discovery that needs to be conducted. There's lots of things that would have to happen in the case before the legal question of whether or not the statute's facially unconstitutional would be decided. What court, which tribunal would decide those, the three-judge panel or the judge where the case was filed?
The issues raised by our friends representing the plaintiffs here, I believe those can be decided by the three-judge panel. It's the issues they've raised are not the same.
Yes, they can, but must they, or how does that work?
Yeah, I think they should, yes, Your Honor, because it's unlike Hull and some of the other cases, I think Latkins that they submitted, where there's a separate, an entirely separate claim, and the statute does require that any separate claims, things that can be resolved without the three-judge panel should be resolved wherever in the originating venue. But here, defendants have filed motions to dismiss based on standing. That's been ruled upon. That's really the only other issue, I think, for, substantive issue before the court. Any remaining issues in this case need to be determined by a three-judge panel.
Counsel, would you concede that if it were an as-applied constitutional challenge, then it could be heard by a one-judge panel? This only involves, three-judge panels only involve facial challenges?
Yes, Your Honor. Yeah. So let's turn then to the allegations of the plaintiff's complaint. The complaint alleges, and I am going to quote from page 8 of the record here, that the program as implemented has no standards or accountability. Participating schools can be operated by inexperienced and unaccredited institutions, can hire unqualified and unsafe teachers, and can teach using haphazard and unproven methods, among other things. It alleges on page 9 of the record that participating schools are not required to be accredited by the Board of Education, can hire teachers who are not licensed by the state board, et cetera, et cetera. These allegations are not specific to any school, but rather all participating schools. That means any school in the state of North Carolina who enrolls students who receive scholarship grants through the program. To the extent that the complaint does contain allegations that are specific to the plaintiffs, those allegations are untethered to the ones I just read about, Common Core curriculum, teacher licensure, whether background checks are required. These allegations in the complaint voice the concerns that plaintiffs have with the program as a whole. There are,
So in your view, does the statute allow the scholarship? So suppose that everything was, that's alleged in the complaint, the factual allegations you described, suppose that those are proven true in a case. In your view, does the statute allow an opportunity scholarship to be used to have a student attend one of those schools?
the Opportunity Scholarship Program allows students to use a voucher, scholarship funds, assuming they qualify, to attend a private school, a non-public school. And private schools, as non-public schools, are not required, to meet all the same, standards that our public schools are. So
What I'm getting at is if we
Right.
said there were certain schools to which you can't use the scholarship funds, would that be inconsistent with what's in the authorizing statute?
can you say that again?
The statute creates the Opportunity Scholarship Program.
Yes.
If a court were to hold there are certain schools to which you can't apply the scholarships, would that be inconsistent with the language in the statute?
Yes, that would be inconsistent with the language of the statute. And that turns me to the remedies issue. What plaintiffs seek here is a remedy that would reach far beyond just these plaintiffs. The remedy sought would invalidate the entire program. They've asked that the court declare the program unconstitutional. They've asked that the court abstain from, selecting any more scholarship recipients, from dispersing any additional scholarship funds, from allocating any additional funds to the program. This would shut down hundreds of schools and affect thousands of North Carolina students.
Can you point me to language in the underlying act, or maybe one of your colleagues can when they step up, but can you point me to the language in the act that compels the agency to fund all these schools, or leaves the agency without any discretion to provide funds to any public school? Or, no, I'm sorry, I said public, I meant private school.
I'm not sure. So the statute itself sets up the general fund that the General Assembly then allocates funding to. And when you say the agency, I think you're referring to the State Education Assistance Authority.
Sure.
And so the State Education Assistance Authority the only role that the authority has is to disperse those funds to students who are eligible and have enrolled at a participating school. And I can be sure to get that exact citation to the statute to you.
Thank you.
But to follow up on that, because I think this is a key issue in this case. So in terms of a remedy, do you think the courts would have the power to impose our own restrictions on the administration of the program so that the statute remains in effect, but by some court injunction, there are now rules that the agency has to apply in selecting which schools are suitable for the scholarships? Can that be done?
You're hitting on exactly, I think, the key point here is that's what plaintiffs need in order to get the relief they seek. They are asking for the courts to rewrite the text of the statute.
Well, that's my question is, do we have the power? Because I assume you say no, and if that's correct, that we can't do that, all we could do is say the statute is unconstitutional. It doesn't provide to the agency the authority to do that. And that's a facial challenge then, because there would be no application in which the statute would still be constitutional. So, but the premise of that is the court would not have the power to impose those rules, for example, through an injunction so that the statute remained in effect. It just could not be applied to certain circumstances, and so do you think we could do that as a court? and I say we, but I mean a trial judge or a three-judge panel, whatever it may be, would a court have the power through injunctive relief to do something like that?
Right, I do not believe that the courts can rewrite the statute. That's the role of the General Assembly. What we do ask is that you analyze the allegations and the remedies and find that what plaintiff's complaint alleges is a facial constitutional challenge, and therefore remand for transfer to a three-judge panel.
There's a lot of case law out there that talks about how we can't level up. So if there are people that should have been included, covered in the statute, they're not included, it creates a constitutional problem, like let's say equal protection. You typically can't add those people in. If the legislature chose not to include them, what you have to do is invalidate the statute. Let the legislature choose to enact a new statute that covers all the people that are required to make it constitutional. But this isn't exactly leveling up what we're talking about here, this idea of us rewriting it essentially or providing these rules. But can you cite a case where this court or our Supreme Court has said we don't have the power in crafting a constitutional remedy to impose through injunctive relief these kinds of requirements?
I cannot, standing here today, I cannot, Your Honor. I'm going to turn my time over to counsel for legislative interveners.
Thank you, and may it please the court, Matthew Tilley for the legislative interveners. Judge Dietz, to answer your first question about what's the governing standard for what is facial versus as applied, I'd point out Town of Beech Mountain, cited in our briefs, as well as the Holdstock case, which involves these three-judge panel statutes. Both cite federal cases for the definition of facial versus as applied. So our argument would be that those three-judge panel statutes, when they used those terms, incorporated the legal definitions, the case law and the understanding, which is really there is no daylight between the federal version of what is facial versus as applied and what we use in North Carolina to make that same determination. I would point out that Town of Beech Mountain cites Fry, which is a very applicable case here. Plaintiffs, if you would read their brief, would say that any fact finding takes us out of a facial challenge and puts us in the as applied box. That's not really the way the cases read. Town of Beech Mountain and Fry say that an as applied challenge represents a plaintiff's protest against how a statute was applied in a particular context in which the plaintiff acted or proposed to act. Similarly, in John Doe versus Reed, which we've cited in our brief, which is a U.S. Supreme Court case, the court has said the label is not what matters. The important point is that plaintiff's claim and the relief that would follow, and I'm skipping a little bit here, reach beyond the particular circumstances of the plaintiff. So the question is not whether you have to engage in fact-finding to get to their claim. It's whether or not you have to engage in a generalized inquiry or whether or not you have to look at how the facts related to how the statute was applied to them. In that context, looking back to the complaint, this complaint and claims can be nothing other than facial. None of the plaintiffs allege that they applied for the program. None of the plaintiffs allege that they attempted to attend a school. In fact, at least one of these plaintiffs is the president of the North Carolina Association of Educators. I seriously doubt that she was seeking to go to a private school or send her kids there, and she doesn't allege it. What these allegations all attack structural elements of the program. The fact that they allow a student to pick, or in the family, to pick where that money goes, and that can be a religious school, that student and family can exercise their rights in choosing a religious school. That is what the plaintiffs are fighting against, that there was no restriction against that. That's a fight.
You're not arguing that they were required to sort of exhaust their remedies by applying to these schools, attending these schools, and being actively religiously discriminated against, are you?
That would be a standing question, is whether or not they have to exhaust all of their remedies in order to gain standing. What I'm saying here is they're not arguing about the way the statute was applied to them. They're arguing about a generalized set of circumstances related to the structure of the program and some generalized facts. And to that point, I'd point to
following up on what Judge Hampton said, I mean, because this, again, seems to be one of the key issues in this case, is in the traditional as-applied case, you would need to attend the school, and you would have to say, as applied to the facts in my case, this program's unconstitutional. It may be fine for other people, but for me, it's unconstitutional. But, and this is what I think we're struggling with in this case, is it's not the traditional type of as-applied challenge. Your friends from the appellees have come up with a novel theory of what an as-applied challenge can be, and, but they are using the theory of an as-applied challenge, which is we're only saying as implemented here. There could be another way to implement it that's constitutional under the statute.
And they're saying as implemented, but I would say that as implemented according to the statutes.
That's the question.
That's the
That to me
question.
seems to be the key question. Can the statute function without court intervention in a way that would be constitutional in your friend from the appellees?
Plaintiffs would say that what they need to allege is that there is no set of circumstances, right, in which this can be constitutionally applied. They're mixing their burden with what they're pleading. They're pleading, and a facial challenge is a challenge that involves circumstances beyond those involving the individual plaintiff. Now, to prove that claim, to establish that claim and get a verdict on that claim, you have to prove that the statute is invalid in all circumstances. That's their burden to carry. But what they need to, but whether or not this is facial or as applied is judged by whether or not the inquiry is generalized or specific to the application to the plaintiffs. I'd point to Fry here, because if you recall, the Fry case involved zoning restrictions in which the town of Kannapolis set a zone in which it said all adult establishments must be within this zone and must be 2,000 feet away from any other adult establishment, a church, a school, or several other types of land uses. Now, the allegation in that case, which the Fourth Circuit said is facial, and that case has been cited by the Court of Appeals, our Court of Appeals numerous times, was that under that set of circumstances, under that generalized set of facts, there was no place for them to put site, and so this was really a blanket prohibition against adult establishments. That's fact-finding. It's generalized fact-finding. It is not fact-finding as applied to the plaintiffs. The relief, again, I would point to this, the plaintiffs tried to narrow that in their brief, but even narrowing it, what they say must change is something that must change with the statute. They say that the statute must be changed to prohibit students and families from directing their scholarships to schools that discriminate in a way that they disapprove of. That would be a rewrite of the statute and the statutory regime. That's an attack at the structure of the statute, the face of the statute, not how it's applied to them. Your Honor, would like to give the parent interveners a moment to make any further points that they have.
May it please the court, my name is Marie Miller here on behalf of the parent interveners. I'd like to address 2 points quickly unless the court has greater interest in others. First, the parent interveners are involved in this case because the plaintiff's claims, if successful, would require a court to narrow the schooling options that the program statutes provide on their face, and it would require that those options be narrowed for every single parent across the state. That feature of the claims makes them facial. And second, transfer cannot wait for a single judge to resolve other matters because there are no other matters in the case. The transfer statute requires transfer of a facial challenge as a whole, not to pieces of it. So the whole claim must be transferred for resolution by a 3-judge panel. Judge Dietz, you had asked about a case where the court could not level up, as that term might be used. Espinoza versus the Montana Department of Revenue is a case in which the Montana Supreme Court recognized that there was no mechanism to prevent the flow of public dollars to schools that were doing things that the state constitution prohibited. And so because there was no mechanism to rectify the problem other than halting the program as a whole, that's what the court had to do. Starting with the first point, no matter how many times the plaintiffs say they concede the statutes are facially valid, they ultimately complain that the statutes give parents schooling options that are too broad. They say the problem here is that public dollars are flowing to schools that discriminate on bases that the statutes do not prohibit. The statutes are explicit that scholarships may be used at any school that, meeting other requirements, does not discriminate on 3 and only 3 bases: race, color, and national origin. That is section 115C-562.5. Again and again, the plaintiffs allege that the program is unconstitutional because scholarships can be used at schools that discriminate on other bases, or that parents can use scholarships at schools in the absence of additional accountability measures. Just a few, paragraph 113, the program uses taxpayer funds to create a program in which a citizen's ability to participate depends on the nature of the citizen's religious beliefs. Paragraph 120, the program funds schools that discriminate on the basis of religion. Paragraph 121, the program funds schools that discriminate on the basis of sexual orientation, gender identity, and transgender status. And I should note that the plaintiff's proposed amendments would not change any of these allegations. The bottom line is that the alleged problems cannot be remedied so long as there is one parent anywhere in the state that has the full panoply of choices that the statutes provide on their face. In other words, once these alleged wrongs are remedied, there are no applications left of the statute as written. That is a facial claim. An as-applied challenge seeks an exemption from a statutory mandate or some prohibition and allows the statute to operate as written for somebody else. That is not what happens here if the plaintiff's claims are remedied. So for example, if a school were excluded from receiving a scholarship students because it didn't meet a statutory requirement, an as-applied challenge could be brought to exempt that school from the requirement. Cryan is another example of an as-applied challenge. The defendants there were seeking an exemption from a statutory amendment. But here, the statutes do not require or prohibit the plaintiffs from doing anything. There is nothing to exempt them from. Instead, the alleged injuries cannot be remedied until the program has no application as written. I can't emphasize it enough. No injunction would both redress the plaintiff's alleged injuries and allow the program to operate as written for somebody somewhere. That is a facial challenge. I'd like to reserve the remaining seconds for rebuttal.
All right. Thank you, counsel. We'll hear from the appellee.
Good morning. May it please the court. My name is Paul Smith with Patterson Harkavy, and along with Chris Brook and Narendra Ghosh, I represent the plaintiff appellees. Plaintiffs do not contend that any act of the General Assembly is facially invalid. Plaintiffs concede that the statutes that authorize the creation of the Opportunity Scholarship are on their face constitutional. And we don't have to look hard to know what it means for a facial what a facial challenge means in the context of this statutory system. We can look to this court's decisions in Cryan and in Lakins. And Lakins, issued just a few weeks ago, reiterated the standard. It means that a statute is incapable of constitutional application in any context.
So where in the statute does it authorize the program not to allow the scholarships to be used for certain schools?
Your Honor, the statutes authorize the creation of this program. There is nothing in the statute that says it is mandatory that schools be funded even if they engage in religious discrimination. There is nothing
There's nothing that says the other side either. And ordinarily in construing a statute, if something's permitted, then the statute authorizes that.
And that's why when you're looking at a specific instance where something has happened that on the face of the statute you can't contemplate one way or another, is if, as implemented as applied, the judiciary realizes that a plaintiff's constitutional rights are being violated because of that circumstance, the judiciary can come in and remedy the constitutional violation at hand. That doesn't require rewriting any portion of the statute. That's just what the judiciary does. And we can see that in a number of cases. Cryan itself, I think, is a great example of that. This court, and we can talk some about I think it's important to really see the details of what was going on in Cryan, and I think that addresses your question. In Cryan, we were looking at a state statute that revived the statute of limitations for sexual abuse claims. The defendant in that case came forward and said, this statute is unconstitutional as it relates to claims that had already expired at the time the statute was enacted. because he contended that they had a vested right in the expiration of the SOL.
Just help me understand. So assume that you prevailed in this lawsuit. What does the court order in favor of your client say?
For the first two claims, that court order could prohibit the direction of funds to schools that engage in unconstitutional discrimination.
Suppose a new school opens the day after the order. How do we know if that new school is subject to the order or not?
The order would be directed to the State Education Assistance Authority. So the State Education Assistance Authority would need to stop funding schools that are engaging in unconstitutional discrimination.
But the statute requires them to fund those schools. So wouldn't the legislature have to make some change to the statute in order to address the court ruling? And that would mean the existing statute is facially unconstitutional.
No, Your Honor. The statute is silent about the extent to which religiously discriminatory schools can be funded.
But my point is, if we have to, through injunctive relief, instruct an agency to promulgate rules and start to do things in order to make a statute constitutional, the statute itself must be unconstitutional if we have to take those steps. So this isn't the same as a sort of scenario where we're declaring one part of a statute unconstitutional, but the statute itself can still function in other applications. The structure of the program in the statute is any school that you want to attend, you can get the scholarships. And if we, as the court system, are trying to step in and start providing rules to an agency that the legislature hasn't authorized to do these things, have to engage in all these criteria, investigate schools, figure out if they're discriminatory, all the sorts of things you're describing. I mean, we've gone far beyond what the legislature authorized in the statute. So that seems to me like we would be saying the statute's unconstitutional. It needs to have more in there.
So I think the problem sort of with that reasoning, I think, is at the outset. The trial court's job is not going to be to sit and say, how can we fix this statute and make it constitutional?
But talking about fixing the statute, doesn't the statute itself, in Part 1, say that schools that qualify are private church schools and schools of religious charter? And aren't you saying that all religious schools are therefore discriminatory because people are, accepted based on what their religious beliefs are?
Absolutely not, Your Honor. That is not our claim. There are many religious schools in the state of North Carolina that do not discriminate on the basis of religion. Our claims are directed at a subset of those schools that do, and we do not contend that the plaintiffs are being subjected to religious discrimination when the program funds schools that do not engage in religious discrimination. So the trial court's job here is not going to be to sit back and say, how can we fix this statute? This trial court's job is going to say, how can we redress the constitutional violation that these plaintiffs have proven? And while our opponents on the other side here want to focus on language in our complaint that is providing context about how the statute operates, the breadth of some of the problems we believe exist with its implementation.
So who would do the implementation? Is it the Assistance Authority? What agency, state agency would be the one tasked with figuring out if a school is discriminatory or not, in your view?
I think that the State Education Assistance Authority would be the most...
So what if they don't have the funding or the personnel that would be required to figure that out? How would that get addressed?
Your Honor, I don't think we've had any discussion about how the remedy can be crafted in order to ensure that it can be implemented.
Well, but that's my point, is we need to know, because if the remedy can't be crafted except to say the statute as it's written is unconstitutional, that's a facial challenge. So that's why it matters. If the court has a remedy it could craft to address the claims without effectively declaring the statute unconstitutional. I mean, I'll point out, your prayer for relief says, declare the program as implemented as unconstitutional under the North Carolina Constitution. And if we determine that the program is driven by the statute, you could just replace program as implemented as declare the statute as unconstitutional. That sounds like a facial challenge to me.
Your Honor, ultimately, the trial court will have the discretion to impose whatever relief it sees fit. We have sought to remove that in the hope, that language in the hopes that we could eliminate the need to pursue this appeal. Prayers for relief, you don't even need to include them in a complaint. We are intending to take that out. At the same time, we are trying to put in additional factual allegations to underscore the extent to which this is not a claim based just on the face of a statute.
But as an appellate court, we are kind of reviewing what was in place at the time the trial court ruled on this. And the prayer for relief as it stands now in the complaint, which is not yet amended, I mean, is is broad. Going on to number 2 to follow up, enter a permanent injunction enjoining the selection of voucher recipients, any further disbursements of money from the reserve fund, and any further appropriations from the reserve fund. So that sounds like much broader relief than relief that would be, focused more on your clients or the class of clients or folks that your clients kind of represent here.
Yes, Your Honor, and I think that, with regards to the broadest possible form of relief that we put in the original prayer for relief is also in dialogue with the third claim that has been raised, which is based in large part on the SEAA not engaging in oversight over the program, including oversight that was required to be conducted by the underlying statutes. So an injunction issued against the program as a whole until they comply with the statutes it's kind of the opposite of a facial claim, if that's what the court chooses to do. For our first 2 claims, which is just about specific schools that are discriminating against the plaintiffs because of the plaintiffs' religious beliefs, a more limited relief, of course could be appropriate in that circumstances that's directed to redress the constitutional injury they are suffering. So this sort of loops back, Your Honor, to your question earlier about what the trial court's job is going to be. It's not going to be to fix the statute. The General Assembly had the authority to enact the statute. We don't contend otherwise. The trial court's job is going to be to remedy the constitutional violation, which in this case would mean that the State Educational Assistance Authority needs to stop funding a certain subset of schools which say, our doors are closed to you because you believe something differently than we believe.
So let me pose my question this way. Suppose we conclude that the statute itself doesn't authorize the agency to do anything other than what they're doing right now. If we believe that, is it a facial challenge in your view then? Or is it, you still think you have a theory of how it's as applied?
No, Your Honor, it would still be as applied because the judiciary has, even if the SEAA today couldn't do that, that's the judiciary's job, is to come in and craft remedies. And again, we see it in MG versus TJ.
The point is, if we conclude the statute compels the agency to do that, the remedy is we would declare the statute unconstitutional, facially unconstitutional, because in every application it is requiring an agency to act in a way that violates our state constitution.
Your Honor, the SEAA is not subjecting the plaintiffs to discrimination when it funds the many schools in North Carolina that do not discriminate. So
but if we think the statute requires them to also fund the ones that do, the statute can't survive. There would have to be a different statute that didn't require the agency to fund those schools as well, right?
Even if you believe that, that would not believe the state statute is incapable of constitutional application in any context. Because again, it is functioning constitutionally when it funds schools that do not discriminate. And those schools could proceed totally unaffected. It's not that we're editing the statute. You see that in ME versus TJ, where the Supreme Court addressed an as-applied challenge and said, but the relief here applies to similarly situated individuals. You see it in Cryon, where this court said, we heard a lot of the same arguments in Cryon from the side that was advocating that was a facial challenge. They said, look, this revival statute, if their arguments are adopted, that means that the statute of limitations can't be revived for an entire subset of plaintiffs that otherwise squarely fall under the facial terms of this statute. And the advocates for transfer there said, look, that's a facial challenge because the relief would extend beyond these individuals because it's curtailing how the statute functions. This court said that was not the rule because the holding would only affect a subset of the claims, those claims that had already expired at the time the statutes had been enacted.
So how do you respond to the parent intervener's argument here that typically as we think of an as-applied challenge, it's often to allow, for example, your clients to attend a school and that they wouldn't otherwise be able to attend. But here, their argument is that your claims are essentially not that would allow your clients to gain something, but really all it's doing is restricting the rights of those intervener parents to make selections of schools of their choice.
What we are seeking would remedy the plaintiff's own personal constitutional rights. And this gets back to the other portion of our allegations here that we didn't hear talked about earlier, where we're actually looking at these families in 4 different communities across North Carolina Their specific religious beliefs, the specific discriminatory policies from schools in their communities which exclude them, allegations that they're bringing this claim because their community is being divided along unconstitutional grounds. Once we amend our complaint, there will be further allegations about how the Meiningers, a family in Fayetteville, in fact did want to send their children to some of these schools, contacted them, and were told that they were not welcome to attend because of their exclusionary policies. So if the trial court below, ultimately I feel like we're a bit ahead of ourselves talking about what the remedy would impose. Possibility of broad relief doesn't mean we must be coming in and we must prove these statutes are facially unconstitutional. That's what Cryon said. You can't impute a facial challenge on a party that doesn't wish to bring one.
So I want to follow up on a question Judge Hampson had, because I also want to understand, so what is the standing theory of your clients in this case that was it's the one that's the basis for standing here?
So the trial court addressed standing in an order that has not been appealed. The standing was both based on them having personally been subjected to discrimination in their communities. And in North Carolina standing, there's also a line where for taxpayer expenditures,
That would be facial.
No, Your Honor.
Why? How could you bring an as-applied taxpayer challenge?
Because it's the statute itself, again, is not incapable. It's the fact, if the statute funded every school that did not discriminate, that would not be challenging the intrinsic facial validity of the statute. It's the fact that the plaintiff is the member of a class that is being subjected to discrimination, and the fact that the program, a portion of the funds going, in fact, are facilitating that unconstitutional discrimination.
Can you give me an example of a case, an as-applied case, where it wasn't as applied to the facts of the plaintiff bringing the action?
I'm not sure if I understand the question. Here are
So, for example, none of your clients, and correct me if I'm wrong about this, none of your clients have either applied to one of these schools and been discriminated against in admission, or are enrolled in one of the schools and now suffering from some form of discrimination, for example.
Two of our plaintiffs, the managers, did contact a school interested in attending and were told they were excluded because of the school's discriminatory policies. Again, that's in the motion to amend the complaint, which we anticipate will be granted upon remand, underscoring how this is sort of premature. That aside, their personal circumstances are still relevant because they are members of these communities and they are being subjected to discrimination because of their personal
As I
religious
understand,
beliefs.
Fry and Beech Mountain, it's not just the act. It can also be, we propose to act in a certain manner, but we are, functionally prohibited from doing so. It's impossible to do so, and so I suspect your allegations are more along the lines of, even applying to these schools in some instances is impossible because of your client's religious beliefs. Or
Yes, Your Honor, and that came out of the hearing on standing, where it's when a school is, and they're oftentimes quite upfront. These are the 20 specific doctrines that you must believe to attend. A family that does not believe in those things, there's an exchange. Do they have to actually walk in the front door and prove, and see them follow through with it? We don't believe that they do.
So just so I understand, in the complaint that's in our record on appeal, are those factual allegations in that complaint?
So the record on appeal includes both the original complaint and the proposed amended complaint. The specific allegations regarding the Meiningers contacting schools and being told that they were not welcome to attend is just in the amended complaint.
So, but in determining whether or not we can transfer something, we can't look yet at the amended complaint, right?
I think there's sort of 2 points in that. First, the fact that we are still making adjustments to the pleadings show that all other legal questions other than a final determination as to the merits, we're not at the stage, right, where transfer even would have been appropriate. Second, because I think that it is quite clear after Hull and Cryon and Lakins that the interlocutory appeal was improper here. The motion to amend was filed well before the petitions for writs of certiorari were filed. So in looking at whether this court needs to exercise its extraordinary authority to come in, it should be able to look at everything that happened.
That's sort of what I'm getting at is, so it would be, what would happen if we concluded that what's in the complaint, the one that's filed, is a facial challenge, and it went to a 3-judge panel, which allowed you to amend the complaint to add those facts, which then created an as-applied challenge. Would that claim stay with the 3-judge panel, or would it go? What I'm saying is I've encountered this legal question, but what if you seek to add more claims to a case after it's been transferred to a 3-judge panel? What happens?
I think that it's going to be very confusing if this case is required to get sent to a three-judge panel before it was time for it to be done so. We don't view this
One
as...
thing I want to be clear about is I'm not, and cite a case to me if you have one for this, but I've not seen a case suggesting if a just obviously facial challenge case is brought, and so it's immediately transferred to the three-judge panel, that the three-judge panel is not supposed to be taking the case now and going through motions practice and discovery, summary, all those sorts of things, that it's supposed to wait till the very end of the case, maybe even a trial on facts if necessary. And then my understanding was if the only thing in the case is the facial challenge, all of the stuff you need to do in a case to get ready to rule on it, discovery, all that, goes to the three-judge panel as well. Do you disagree with that, or is there cases you think?
I do disagree with that. I, of course, for the record, think that even if you can find a facial challenge in our claim, there are unavoidably also claims that are not facial challenges. But if you look to just the face of the statute, really, that becomes clear. In the briefing here, defendants proposed changing this language so that transfer only occurs after all other claims have been resolved by the originating court. That's not what the statutes say. The statutes say the originating court are supposed to resolve all other matters. If you look at 81.1A1, it says all other legal questions or all other questions of law.
But in Hull, didn't we interpret that to mean other claims, other matters unrelated to adjudicating the facial challenge?
And it's a Holdstock and Lakins, I believe, address that. It's all other matters not contingent upon the outcome of the facial challenge. So these questions, overseeing discovery, adjusting the pleadings, the myriad other issues that can come up, those, as in Lakins, when it was talking about a 12B1 motion, are predicate decisions that need to be made before you get to the final determination. So the final determination is almost contingent on that process, not vice versa.
But see, I thought in Hull, we were construing that concept to mean, so for example, I think it was intentional infliction of emotional stress in that case. It was also brought that and everything that needed to be done in that claim went forward before a single Superior Court judge before the transfer. But if all that was there were the facial challenges, it would immediately have to be transferred. You couldn't allow the single judge to do any discovery or anything like that in the case.
I think that that's much further than Hull went, if I'm recalling correctly. I believe that trial was allowed on all of the claims, including those that were contended to be unconstitutional. The trial court just recognized we may not need to actually reach the Constitution. Maybe they lose on those claims, in which case we'll never need to reach the question. We can bifurcate this for a jury verdict so that we can easily sort of come in and clean up after the case if one of the claims gets tossed. So let's go all the way to a verdict before we actually decide whether we even need to reach this question. And I mean, again, if you look to other portions of it.
Yeah, I thought that was because if they prevailed, and maybe I'm remember, isn't Hull an alienation of affection case?
It is,
So the
yes.
theory was if you lose the alienation of affection claim, you don't need to send it. If a jury enters a verdict to favor the defendant, you don't need to transfer to three-judge panel to see if the alienation of affection claim is constitutional because their judgment is in favor of the defendant. I thought that's the point they're making. But the idea was if you're doing anything with that claim, you got to do it in the three-judge panel, and we'll get rid of everything else first. Is that?
Your Honor, I think that the claim itself was still litigated before the individual Superior Court judge. They just said you can have a special verdict form. So for alienation of affection, you can see the damages for that one and the damages for all the other ones. And if it needs to come out at the end of the day because eventually a three-judge panel finds this unconstitutional, we can do so. That's a harder case than this case because having a jury trial over a cause of action that may be unconstitutional, you could say that's sort of contingent on the outcome of whether you can actually bring that claim. Here, discovery disputes, adjustments of the pleadings, those sorts of things are in no way contingent upon the outcome of any constitutional claim, even if the court has concerns that it might be a facial one. And ultimately, I think that also sort of informs one of the real problems here. That is, there's a lot of conversation about remedy. A lot of these cases that we see the defendant citing arise in this very different context where it's like, all right, well, a plaintiff has been pursuing this legal theory up until now. We're at the end of the day. How broad is the relief going to be? Have they met the federal requirements for First Amendment standing? And there's a conversation had about what's a facial remedy, what's an as-applied remedy. These statutes don't focus their inquiry on what the remedy is. They say when you're challenging the facial validity of an act of the General Assembly, that's what's triggered here. If the trial court eventually, once this is litigated, and again, we feel like these allegations about individual plaintiffs and individual schools in their communities are as applied. If they find in favor of those plaintiffs, they will need to think about what remedy is appropriate, what remedy is within the scope of their authority to do, given the statutory text. And if the defendants want to argue that that relief needs to be more limited than we will ask for it to be, they should raise that argument there. But the fact that that could come up at remedy stage doesn't sort of fundamentally change the nature of the claim that we're bringing and transform it into one that is contending that these authorizing statutes are incapable of constitutional application in any context. And really, when they're invoking these other cases, when they're invoking cases that are exploring areas where the courts feel that it gets a little strange. You know, this remedy that we're talking about, it feels a little bit as applied, it feels a little bit facial, and then they're having to grapple with that. This court's already addressed how the three-judge panel statute applies to cases in that space, because that is the case that Cryon was. It was a case where it said, well, look, we're not saying the statute's incapable of ever being applied, we're just looking at a subset of claims. And even though this ruling is going to be relevant to a lot of people other than the plaintiff here, even though it means the statute is not going to actually be functioning the way you might read it to be, that's still not a facial challenge to the validity of the statute, because the statute still exists. It is still operating constitutionally in other contexts.
So can you give me a context in which you would contend that private church schools could receive funding under this statute and still be constitutional?
Yes, Your Honor. If a religious school that does not discriminate against students on the basis, on constitutional grounds, operating within, under an SEAA that is engaging in what it's supposed to do as far as overseeing the program, would still be eligible to receive funds here. We're not bringing an establishment clause claim that says, you know, religious schools can never get funded. We're saying specific policies, looking at the handbooks, looking at the admission rules for these individual schools, which exclude certain people on grounds that are not constitutionally permissible, funding that specific subset of schools. That's what's unconstitutional. So many schools don't. A lot of schools, religious and non-religious alike, would not be affected from a ruling that finds in plaintiff's favor on that count. And the judiciary, with an obligation to redress constitutional injuries, can put a stop to that constitutional violation without having to get in and declare anything about the statute unconstitutional, without rewriting the statute. And the mechanics of what that remedy looks like is just something we're going to need to address when it's time to address it. Not early in the process when we're still adjusting the pleadings, when we're still actually finding out what's going on the ground in these communities.
So I want to kind of looking forward with a hypothetical, sort of an unhappy hypothetical for you, and if this is an unfair question, feel free to tell me, but trying to think about where this case goes from here if we were to hold that the trial court erred and this was a facial challenge. You know, what position does that put your clients in? You know, having argued that this is an as-applied challenge, which presumes there is facial validity to the statute. I mean, what position does that put your clients in going forward in this case? I mean,
it seems really messy, kind of procedurally and top to bottom, if these claims, if now we have to challenge the underlying validity of the statute that we're not trying to do. So we'll have to step back and sort of think about what that means, because that's not the claims we're bringing.
But just to follow up, I think this is what Judge Hampson might have been getting at this point, that going to whether we should take cert in this case, for example. I mean, one issue is, if it turns out that when we examine the remedy in this case and get into what I think Citizens United says, you know, is the most important thing in determining if facial or as applied is the breadth of the remedy. And if it turns out the remedy that courts would need to impose here in order to remedy the constitutional violations you've alleged will be so broad that it's effectively facial, everything that the Superior Court judge currently adjudicating things in this case has done would be void, because that court would not have subject matter jurisdiction. So that's a pretty big reason for us to make sure we're getting this to the right court, so that everything that happens, amending your complaint, all the other things that the parties are going to litigate here is before a judge where the orders are actually going to mean something. So that's sort of what we're focused on.
Yeah, and I recognize defendants have raised that argument. I'm not sure what or why they think anything happening right now in the trial court would need to get thrown out. If the trial court issues a remedy, and one day this court finds that remedy could only have been issued if it found that an act of the General Assembly was facially unconstitutional, that happens at the end of the proceeding. You could simply review that. All the predicate decisions leading up to that, under the statutory text, the 12b1 motion obviously stands. It's listed specifically. All other legal questions, other than the determination as to the facial validity of an act of the General Assembly, are within the originating court's jurisdiction.
Well, that's if we accept that reasoning. I'm not persuaded yet that that's what the legislature means there. I think what they mean is if you have a claim for negligence and a facial constitutional challenge, finish the negligence claim first and then send the constitutional challenge to the three-judge panel. Don't split it at the beginning, which I think is what Hull was saying. Litigate the alienation of affection, whether or not there's liability there, litigate the other claims. Then when it's all over, if you wanted to do discovery on the constitutional question or do anything else, it goes to the three-judge panel and you resolve all that and then get the legal question of facial constitutionality. And if that's what it means, then even the discovery ruling here would be void for lack of subject matter jurisdiction. If it were things that needed to be done by the three-judge panel, every decision by the single judge would be void. And that's a concern that
Your Honor, there are safe harbor principles as well, where if a Superior Court judge is operating under good faith belief that they have jurisdiction, that there's no need to simply throw everything out. We think that would certainly apply in this case. So I think even in that circumstance where you take that very broad reading, I think we would have to go back and we would have to relitigate the remedy in front of the entity that would have jurisdiction at that point.
And is it possible, I know your time's getting short, but is it possible for a single trial judge hearing what is presumably an as-applied challenge to get further down the road at some point and realize, oh gosh, I guess this is a facial challenge. I should now transfer it to the three-judge panel.
Yes, Your Honor, and that sort of consideration is what required by the statute. Before transfer happens, the Superior Court judge is supposed to recognize that transfer must be sent because resolution of the facial validity of an act of the General Assembly must be made in order to completely resolve any issues in the case. So if the circumstances change below, and when it comes to judgment or remedy phase, the trial court says, actually, I'm seeing things here that I don't think I actually can do. I need to involve a three-judge panel. The changed circumstances, whatever they might be, certainly they could revisit it. And that's the judicially efficient way to do this. The General Assembly didn't mean to convene three judges for every miscellaneous subpoena enforcement dispute or protective order that's coming in. They cared about three-judge panels actually deciding the facial validity of their acts. So that's why this sort of bifurcation, it very much works to the advantage of judicial economy because the three-judge panel only needs to get involved when it's actually time for the merits of the case to get involved.
All right, thank you, counsel.
Thank you.
We'll give you 2 minutes, counsel.
Thank you, I appreciate it. Couple of quick points. So the plaintiffs have said that to remedy their alleged problems, they would need to prohibit the disbursement of funds to certain schools. Well, to do that, you would have to change the range of options that the statutes currently provide on their face to everyone. There would be no application of the statutes left as written. That is a facial claim. And as far as Hull goes, Hull involved a constitutional challenge that came in the form of a defense. So in that situation, the single trial judge could resolve other claims without ever reaching the constitutional challenge. And that's why the single trial judge could address other matters. Rule 42 says the single judge maintains jurisdiction over all other matters other than the challenge to an act's validity. There's no slicing and dicing of a facial challenge for the single judge to resolve some pieces of it and the three-judge panel to resolve others. The entire challenge, by the language of the statute and the rule, goes to a three-judge panel for resolution. Finally, unless the court has other questions, the relief that the plaintiffs say they need is exactly the kind of relief that was needed in Espinoza. And that required the court to invalidate the entire program, which is the hallmark of a facial challenge.
All right, thank you, counsel.
Thank you.
Thank the parties for their arguments, and we'll adjourn. Mr. Soar?
All rise. This session of the North Carolina Court of Appeals is adjourned.